Good morning. Mr. Siminya.
Good morning, Chair and Commissioners. Today we have Reverend Chikane to help us with the work of the Commission, and Mr. Soni will take him through.
Thank you.
Good morning, Chairperson and Commissioner Como and Gabriel. Our witness today is Reverend Chikane. May he be sworn in, Chairperson.
Thank you. Good morning, Reverend.
Good morning.
How are you?
I'm okay now.
Fine. Are you going to take an oath or affirmation, Reverend?
I'll take an oath.
Yes. Do you swear that the evidence that you will give before this commission will be the truth, the whole truth, and nothing but the truth? If so, raise your right hand and say, "So help me God."
So help me God.
Thank you. Mr. Soni.
Thank you, Chairperson. Reverend, before you is a file which contains an affidavit, and you'll see that on the top right-hand side of the affidavit there are page numbers, starting with page 1902.
That's it.
Now, is that an affidavit you made in respect of the evidence you are to be give today?
Yes, I did.
Can I ask you to turn to page 1925? Is that your signature towards the end of that page?
Yes, it is.
Do you confirm that the contents of this affidavit are true and correct?
That's it.
Now, Reverend, before you start to give your evidence, it would be instructive to briefly place on record the backdrop against which you were asked to make this affidavit and now to give your evidence. In essence, that backdrop is as follows. Evidence has been led at this commission on the prosecution of some of those from the apartheid police force who were part of a plot to murder you by applying a deadly chemical substance to clothing you would go on to wear in order to stop your resistance to the apartheid state. That is one of the few prosecutions that have been instituted after the TRC process in respect of conflicts of the past was finalized. You have written about these and related matters in your book, The Things That Could Not Be Said, both from the perspective of a victim as an activist who later served the country's first democratic government. As emerges from your book and your affidavit, you have reflected deeply on the pre- and post-TRC matters and have written on these matters very elegantly. In the circumstances, in leading your evidence, I intend sticking to the script, as it were, and invite you to feel free to simply read from the affidavit where you wish to do so, and, of course, amplify any issues that you want to. With that approach in mind, I'm going to ask you to please turn to your affidavit. Now, in paragraph 2, Reverend, you indicate in your long service to the country and to the church and to the people of South Africa, the positions you presently hold. Will you place those on record, please?
Yeah. Well, currently, I'm an emeritus pastor of the Apostolic Faith Mission It's one of the largest Pentecostal churches in South Africa, and I've been in the leadership of that church for 23 years as international president of the church, but I'm retired now. And the other current engagement, it's chair of the South African chapter of the anti-apartheid movement on Palestine, and we deal with the crisis in Palestine per request of the Palestinians, that South Africa is better placed to understand what they are going through. And then I'm also co-convener of the Africa and African Diaspora Conference. We held it in 2021, bringing all people of African descent and Africans together. We're meeting again in October. In terms of the former, at my age, there's lots of formers, former this and former that. But what is important is that I became moderator of the Churches Commission on International Affairs of the World Council of Churches, and we dealt with conflict situation from 2016 to 2022, which took me to all these places where there is conflict, Middle East, Latin America, and other places. I won't go through the details. Our General Secretary of the Council of Churches, Institute for Contextual Theology, and I was part of the Independent Electoral Commission for the first democratic South Africa, and then became part of the United Democratic Front. We're founders of it, and I was vice president of the United Democratic Front. And then 97, I was elected into the National Executive Committee of the African National Congress. In government, which is more relevant, I served as a special advisor. That's how I went into government of Deputy President Mbeki then, and then became Director General in his office. When he became president, I became Director General and Secretary of Cabinet, Secretary of Cabinet. During Mandela's time, I was deputy. It was a transitional management. They made me deputy Secretary of Cabinet a short while before he resigned, so I could take over that responsibility. Yeah, that's about the background.
Yes. Now, Reverend, one of the perspectives on which you've talked about in your affidavit and in your book is one as a victim of apartheid crimes against the people of South Africa, and secondly, the role you played in the struggle to bring an end to the apartheid system. So those are the two perspectives from which you, on which you base your book and your affidavit. Now, Reverend, at paragraph 7 of your affidavit at page 1904, you point out that notwithstanding the fact that you've come through these trials and tribulations that were imposed on you, this is still a painful memory for you. Can you explain to the commissioners why that is so?
Yeah, I don't have to read the paragraph, but I just want to say that firstly, because my case ended up in court, so it becomes of interest. But I've been asked to give evidence in various investigations, commissions, court cases where they review the cases of the old time. And I mean, all the time I'm asked to come here like I do today. It's a painful thing to repeat. I want to go past, the past must go, but it never goes because you have to keep on repeating it, go to,
The past is haunting you.
And I think it was Commissioner Como who said that.
I'm saying the past is haunting you.
oh yeah. It's actually a problem. So my dear wife said I must write it so that I don't have to repeat it. She said, I won't travel with you if you talk about your torture, poisoning, and etc. And she's here today. But the case that is before us is the one I really wanted to know about. You know, the torture in prison, John Foster, Krugersdorp, third-degree methods, injuring my back up to now, third vertebra is still a pain. It's not difficult to deal. It wasn't difficult because I knew the people who tortured me. If you spend 6 months with them torturing you, you end up calling each other by first name. It's strange when you are in their custody. And some of them I met after the liberation, and I went to one event, we had a guest, and the security that took care of our guest was one of those who tortured me. And that's the nature of the settlement we arrived at, where the people who fought against each other now work together. And it's quite an experience. But that's what, when you look at my book, it's not what I was worried about. I was worried about what I didn't know. And it's how I was poisoned, how it happened. And that was the real focus for me. And but indeed, it's not a nice thing to go through the details about people putting poison on your underwears, chemical weapons, stuff, and you get hit by it. Yeah, the details are history. I don't need to repeat them. But I survived in any way, so I call it a miracle.
Yes.
I did meet, it's not in the statement, but I did meet the scientists who produced those chemicals. And one of them entered the room and said, you are, and I'll use his language, I don't normally use this language, you are damn lucky you are alive, because the chemicals we produced were meant to kill. And if you look at the plea agreement, they do say that when they looked for a chemical to deal with me, they asked for one that kills. They said so in court. And, but I survived. And that's a miracle for me.
Now,
And you didn't say to him, if God is with you, who can be against you?
Well, I didn't put it in that way. I said I am a miracle. I mean, the Bible says they could use chemicals against you, poison, and you'll survive. And this is a case where but it was painful. Yeah, I mean, when I came out of Namibia, where the doctor spent 5 hours keeping me alive, and they were the only 2 doctors in the hospital. And they had to fly out there. I had to be flown to Johannesburg, and they had to have a nurse with the equipment to keep me alive in the plane to come back to a hospital here. And it hit me 3 times before it was found out what it was.
Reverend, now, your statement doesn't contain these details, and that was done deliberately so as not to
Yeah.
exacerbate the trauma that you've been through. But details of that are contained, or some details are contained in the plea and sentence agreement
Document.
that was entered into. And that is Annexure A to your affidavit, am I correct?
Yes, that's correct.
And that's referred to in paragraph 8 of your affidavit.
Yeah.
And then in addition, one of the issues that you address in this affidavit and express concern about is the manner in which the prosecution itself was handled. And that is contained in an affidavit or in a letter you sent to the then Minister of Justice. And that letter, which we'll get to in a little while, is Annexure B to your affidavit.
That's it.
And you point out that you will, in paragraph 9, that you will refer to both these documents
Yeah.
a little later in your affidavit. But again, Reverend, and it is important because you are one of the few people who can look at the matters that the Commission is dealing with through various prisms. One as a victim, and secondly as a person who thereafter Now, can I ask you, Reverend, is the fact that you had a foot in several, one foot in the position of a victim and another in the position of those who were dealing with TRC matters, what effect has that on the perspective you now have of the post-TRC process? I think you deal with that in paragraph 10 of your affidavit.
I must start by saying that I had my advantage, firstly, before 94, was that I was involved in the struggle, and there was a war, and I was detained, tortured many times. So I understood that we're in a war. So it wasn't that when they catch you, you are like a soldier. They've caught you and they torture you. And if you survive, you continue fighting. And so that's why this particular matter would have taken about 18 years for me to crack it. So we started investigating whilst I was sleeping in the hospital in Wisconsin. Interestingly, it hit me here, and we're going to go and meet President Bush, for comprehensive sanctions against South Africa. And that's when they hit me with it, and they deal with it in their affidavits, which says they wanted to stop me from doing that. After I recovered here, I went to, people felt I must go and rest. My wife was studying in Wisconsin. Go early so that I can meet the rest of the team, Desmond Tutu, Bear Snoddy, and others. And I went early. But the baggage I had, which had the clothes that were poisoned, came back from Namibia. And I packed new clothes on it. I didn't empty it. And first night in the United States, when I woke up the following day, it hit me again. And it was 3 times before. So we started being suspicious. And when it was confirmed that this was a chemical weapon stuff, my communication with South Africa was that we must investigate this. So if you are in a liberation movement, investigation was part of it. It was counterintelligence and investigation. So by the time I returned, we knew There were 3 laboratories in South Africa which produced this. So I'm just giving a picture that this story didn't start after the new government. When we went into the new government, I had an advantage that I ended up in the president's office. No. I was asking them whether or not they knew about my poisoning and if they could assist me. I had to write it carefully so that I'm not sued for accusing people. And it went on until we went into government. Now, once I was in government, in government, you could interact with the prosecution team and other people. So, in government, at the presidency, you discuss these issues. And at the same time, I'm a victim. So, what I would hear, of course, it's where it involves the president, where we have to do some work. The details are in the affidavit. And I did not look at this matter waiting for somebody in government to assist me. I took it upon myself that I'm going to crack this thing. And we worked very hard on it. I used all the available means until we cracked it and found the names. Now, I do refer to it in the statement, but the interesting thing for me is that the first name I got was the person with 3 names. They are in the affidavit. And it sounded like one person, so we're looking for one person. And then we discovered later, decoded it, that those were surnames of 3 people. And then once I got to know who these people are, we then wrote to their lawyers. I wrote to their lawyers to say, I have reason to believe that your clients know about my poisoning. I didn't say accuse them, to make sure I'm on the safe side. And they resisted initially, but ultimately they accepted it. So I was dealing with
Sorry, was Wagner one of the lawyers at that time or not?
that was their key lawyer.
Yes.
And I believe he was the one who was commissioned to protect all these perpetrators. And I believe that he would have had this file of the National Executive Committee minutes of the ANC and will come to that particular matter. But before, in my affidavit, I talk about, I was involved in thinking about a truth commission before it was there, during the apartheid days. We debated it in the church because we wanted to work out how we're going to live together after this war. It was terrible. People died, people disappeared, and then we ended up debating with activists. We researched what happened in Latin America in particular. This morning I had to check it again about that information we used during that time, before 94. And when 94 came, we had debated this issue about the Truth Commission. It might interest you to put on record that what came out of the parliamentary process was not what we had agreed upon. What came out of the parliamentary process equalized, perpetrators of those who were resisting apartheid and those who were defending apartheid. We were talking about the apartheid perpetrators. And so I participated. My advantage is that I participated in the development of the Truth Commission. We knew the weaknesses. post the Truth Commission, we had to talk about what do we do with the perpetrators we don't have evidence against. You know that they did something, but you don't have evidence that will stand the test of the court. And that's where the issue of guidelines, so that was my advantage. I would be involved in the debate about the dark guidelines, and then how we get people who have not come out to tell us the truth.
Yes. Reverend, in fairness to the commissioners who will,
Just before that, Mr. Soni, Reverend, where you speak of the outcome is not what was initially envisaged. Is it what you deal with at paragraph 32? The last sentence, if I could read it at 1912, where you say such a result could be achieved in the name of equality, namely by balancing people to be charged between the perpetrators of gross violations of human rights on the one side and of the apartheid regime and ANC leaders who were involved in or who commanded the war of resistance against apartheid regime on the other. Is that what you're referring to?
Yeah. That's correct.
Reverend, as I say, in fairness to the commissioner, you deal with all these matters that you've talked about in general in a systematic way in your affidavit. And I think it would be more helpful, and I say this with respect to the commissioners, if we more or less follow that, so that when they are writing their report, they're able to put it all together. Because as I said, your statement elegantly sets out these matters, but in a more systematic manner.
I agree. It's only that the story is in my head. So.
Yes, and
Yeah,
unfortunately, as the person leading your evidence, I have a duty,
Yeah.
and of course that is a bit obstructive to your thinking at the moment, but I have a duty to the Commission and especially the Commissioners to ensure that the evidence comes out as comprehensively and as systematically as possible. So you will forgive me.
No, let's do it
as
that
it were, hold you on a tight leash. Now, one of the things that I wanted you to stress, Reverend, is a matter that's referred to in paragraph 11 of your affidavit. And that is that you point out that straddling all those positions that you had, both as an activist in your earlier days, as, for example, a detainee and so on, and thereafter being an actual victim. And your victimhood is a slightly different one from many of the others. For example, and I know you read at the time that Dr. Agate was detained, you were also detained, as I understand the position.
Yes.
But you survived, as it were, and many people like Ahmed Timol and Dr. Agate didn't survive. And I mean, that's the tragedy of our history. But what you are able to do, having survived and wearing the hat of a victim, and then seeing the perpetrators brought to book, and I'm not going to say justice because we deal with your concerns about the manner in which the prosecution was dealt, but putting all that aside, putting all of that together, I understand you have a better understanding of the times that we came from. And you reflect that in paragraph 11 of your affidavit.
Yes, I do. You want me to go through it?
I would,
Yeah.
it
I,
would be
I
quite
say
helpful.
that be that as it may, which is up to the 10, paragraph 10, my involvement in the two roles that I have identified above gave me a better and I dare say sharper understanding than many others of the complex and emotive issues that such cases involved. I was also aware of and participated in debates that took place relating to what the TRC process sought to achieve, and when those expectations were eventually not wholly fulfilled, how to nevertheless protect the gains we had made when we sought to transform a racist, autocratic, and authoritarian state, dedicating to minding the interests of a small minority into a transparent, caring, and democratic state that would see to the needs of all its people.
And then in the next section of your affidavit, you've alluded to parts of it, you deal with the pre-transition period. If I
Yeah.
could just ask you to look at paragraph 12 to 14, reflecting on the early days
Yeah.
of the birth of the TRC idea. If you could tell the commissioners how that came about.
Yeah, in paragraph 12, I submit that for the purpose of putting things in context and perspective, it will be helpful to begin by briefly reflecting on how it came about that the TRC process was brought into being. In 13, I was part of those who engaged in debates and workshops about the idea of a truth and reconciliation mechanism to prepare for the time when we will have to create a society where those who fought each other against each other bitterly, for that matter, would live together in peace. This happened within the church first, as I said, then with activists involved in the struggle. We grappled with the dilemma of the need to know about what happened to victims of the apartheid system, especially where we did not have the evidence, and the need to ensure justice was done on the one hand, and on the other, strategies to cross the bridge from a violent, unjust, oppressive system to a just and peaceful society. During the negotiations in the early 90s, the matter of how to deal with crimes of the past came to the table, and debates on some sort of truth and reconciliation commissions to help us cross the bridge from a violent apartheid society to a just and democratic society were considered. The consensus was that we would never know what had happened to those who were assassinated, killed, or who have disappeared without the cooperation of the perpetrators. What it means is that if somebody disappeared, unless we gathered evidence, we would not be able to find out how that person died, because most of the cases were done covertly. Where there was sufficient evidence of gross human rights violations, the prosecution authority would prosecute the perpetrators because you have sufficient evidence. Can I go to 15?
Yes, please.
On the first category of cases, a major compromise had to be made by offering amnesty to the perpetrators in return for information or the truth. The sacrifice that had to be made was that would not bring the perpetrators to justice once they had volunteered to tell us the truth. Hence, the commission was set up and called Truth and Reconciliation Commission. I must elaborate here because it was a painful discussion. If you're not going to know, people will die and you'll never know. But if you got them to give you the information, and the strategy was, give us the information and then you get amnesty. But if you don't give us all the information, we find out later you committed other crimes, you'll be charged. And the case in point is former Minister Flock, who went into the Truth Commission, spoke there but never spoke truthfully about my case. And when we got more information, he had to be charged. So it was a question of how you get the information you can't get unless they cooperate. I think that was the debate. And for victims, it was painful before because you get to know about it, but then you can't charge them.
Yes.
And I'll not go into that detail, commissioners, but I went to that court where the 5 were charged, plea bargaining, suspended sentences, and they walked away and went home. I went back to my office, and the deep depression that went with it, that's the end. They have gone home, you know. It's a very painful exercise. And I had to leave at 2 o'clock from work and said, I can't continue working, I'm going home. But that was the price that we had to pay. And in 16, it is important to point out that at this stage, the final TRC Act was not what we wanted, as I've said. One of the key issues that was major concern was that the TRC Act equalized gross violation of human rights and the response of those who were resisting the violence of the apartheid system against the masses of our people.
This is a point that Commissioner Como made to you a little earlier when he asked about the equality you were referring to, I think in paragraph 32. It is the same issue.
That's it. It's the same issue.
And then in paragraph 17, looking at all the dilemmas that the activists and victims faced, you set out how the process, or how you envisaged the process would unfold. To tell the Commission about that.
In paragraph 14, based on the reasoning in 14 above, we began to talk about giving an opportunity to perpetrators of gross violations of human rights to come clean and disclose everything they did or knew in return for amnesty. Anyone who failed to disclose or take advantage of this opportunity would face potential prosecution once evidence became available. We thought that in this way, we would motivate perpetrators, or maybe the word motivate, cause the perpetrators. Maybe it would be a better word. Cause the perpetrators to come forward out of the woodwork, as I called it. We also expected that once one individual did so, the others would be compelled to follow suit as information from their colleagues would implicate them or make them witnesses. We anticipated that the strategy would have a domino effect, and the approach became a key element of the TRC Act. I need to add, it does come later, that my pain, when you read my letter to the minister, is that the plea agreement gave more information about others when you read it. And I expected that the prosecution authority would pursue those cases based on that plea agreement. Nobody did anything about it, and I do refer to it. And I also refer to the issue. I've talked to media to say in my book we have the list of chemicals which were ordered, 49 of them with dates, etc. They were very meticulous. They didn't just take the chemical and not record. They were very meticulous. And mine was in that list, which was used against me. Nobody up to today ever asked against whom were the rest of the other chemicals used. Nobody. And I published them in my book at the end.
And you also, as we'll come to in a moment, refer to the fact that a list of intended victims, which included you,
Yeah,
had existed,
referred to.
but it was not pursued.
yeah. In there, I mean, if there's a plea agreement that says there's a list in court, I expected the police and the prosecution to pursue that and say, give us the list. You've talked about a list. Who are the names of the people? We don't know up to now. It's only my case that's known. I've had people like from Netherlands coming to me and saying, after hearing my experience, saying, you know, I've experienced something like this. Can I understand what happened to you? For the commissioners, I mean, the plea agreement states very clearly, and we got to know that this project was a military project. It was the military who were in charge. Production of the chemicals were Surgeon General's office, whom I also wrote letters to. And the army was to deal with those outside the country and the police to deal with those of us who were in the country. Nobody has asked what the army, who did the army deal with? Nobody has asked that question. And I thought that plea agreement had all the information that you need to do further investigation. But they walked home, and then nobody worried about it.
Now, Reverend, you've indicated how painful it is to watch people who wickedly intended to poison you in order to kill you and then walk free. You indicated how painful that process is. In paragraph 18, you point out why nevertheless such compromises had to be made.
Yeah.
Could you tell the Commissioner?
I should perhaps point out that the decision to make compromises arose against the following backdrop. First, our transition to democracy and a transformed society was going to be through a negotiated settlement, not a winner-take-all war. We did debate the issue about Nuremberg trials during that time, to say you only have Nuremberg trials if you have won a war. Then you couldn't do Nuremberg trials if you didn't win the war. As a result, it was necessary to assure those in power and the beneficiaries of the old South Africa, that notwithstanding all the wicked deeds that had been committed in defense of an evil system, the transition would not lead to a period of some type of revenge against them, which would be very lawless, and being the masses taking those people on. The take in this regard was that actions by the liberators that would be classified as illegal in a legal system that the majority saw as inherently unjust would be similarly protected. So there was no expectation, except for people who really just committed crimes. I mean, people did things that were straightforward criminal, which had nothing with the struggle. But for those who fought apartheid, you can't equate the violence of resistance against the violence of the oppressor. Yeah, and we deal with this now in the Middle East as I do today. There's a difference, and people expect that those who are powerful or have power legitimize their violence, and those who are victims can legitimize their violence.
The philosophical basis for that obviously is that freedom is an essential quality of good human life.
Yeah.
Now, in paragraph 19, you point out that notwithstanding the sort of sacrifices being made and the fact that revenge was not going to be the order of the day, many of the perpetrators didn't come forward.
Yeah, that's correct.
And as a result, the post-TRC period became quite an important issue because it had to deal with those who defied the hand of friendship that had been extended.
Yeah.
And then you deal with that in paragraph 20. What was the expectation after the post-TRC?
Paragraph 20.
Yes.
Yeah. After the TRC process had been finalized, there was an expectation that prosecutions of those who had been denied amnesty or had not applied for amnesty would proceed as had been recommended by the Truth and Reconciliation Commission in their final report. This, of course, depended on availability of evidence to secure a conviction.
But you point out that things didn't go according to expectations, and you deal with that in paragraph 21.
Yeah, unfortunately, some parts of the TRC recommendations were not acted upon as recommended by the TRC or in the form in which the TRC recommended for various reasons. Some would be that government modified the recommendations in terms of the quantum of the grant victims would get.
And this refers to the fact that the TRC recommended that victims of human rights abuses ought to be compensated financially.
That's it. And they had recommended 600,000 per victim.
Yes.
And the government ended up with 30,000. And the issue about this, I mean, I don't need to elaborate because it's not in my preview, but the issue here was how, if you compensate those who were declared victims by the Truth Commission, who were about, in the main, about 2,000 people who had appeared there, and those who were referred to, like myself, I didn't appear at the Truth Commission because I didn't think my story needed to be dealt with there because it was known. My profile made my stories known. There was no need for me to go there. But I'm still classified as a victim. And the dilemma was, if you compensated those who appeared at the Truth Commission, what about the millions of victims across the country? How are you going to do that? And that was the dilemma that generated this discussion. And the view was you give the victims a symbolic amount of money, but make sure the society repairs what was damaged. And I usually make one example about wheelchair, that instead of having wheelchairs for those who were victims who came to the Truth Commission, you must have a policy that gives any South African a wheelchair who needs a wheelchair. You know, that type of policy that meets the needs in different ways, education, other issues. It was a controversial issue, so I know that because I was there. It was very controversial. That's why when they asked to pay me the money, I asked them to give it to those who are more needy and not give it to me. That's one of the issues I'm referring to that were modified. And then in addition of victim who qualified for reparations in terms of the TRC report, or because of failure of the system, in other instances, it's the failure of the system to do what it's supposed to do, or because of the political complexities of the time. I thought the political complexities are the ones that are more relevant to this commission. My understanding of the terms of this commission is that its focus is on the area of failures of the system and the area which I call political complexities of the time.
And you say you had a first, you had an immediate perspective of this in your position as first Deputy Director General of the, Deputy Secretary of the Cabinet and thereafter Secretary of the Cabinet.
Yeah, I state that in paragraph 2. I don't have to repeat that because I've already said what my role was. But I'm saying at the bottom of that paragraph, I have views about that difficult moment and had to deal with both from my vantage point in government and as a victim who had unfinished business with the TRC processes.
In the paragraphs thereafter, you set out your observations on the post-TRC processes. That's from paragraphs 23 to 27. Could you tell the commissioners you could read from it or elaborate to the extent that you want?
Yeah. In general, at the end of the TRC process, most departments, and I'm expressing my view here, my observation, because I was there, most departments of government did not see a role in post-TRC related matters. Many had new responsibilities to worry about. You were transforming a huge machinery, transforming the army, the police, departments, reconstruction, and they worried more about what they had to do in each department, particularly regarding the transformation of the apartheid state and its institutions and structures. For those
Sorry, before you go there, the persons who were manning these departments in regard to transformation, who were they? In other words, from where did they come? Were they former activists who we're now going to build the new South Africa.
Yeah, by the time the TRC, I've forgotten the timelines now, by the time the TRC released its report, we had managed to get new people to head most of those departments. So like for instance, the security cluster, they were all from the liberation movement, but others were delayed. You remember the commissioner of police was 5 hours for some time, and the army was nearing. So there are some who stayed a bit longer, but others were new. But in this particular debate about transformation, it's more about the new generation, because the old order was not about transforming the system.
And-
That's what I'm referring to.
And they saw their focus to be not the TRC matters, but transforming the departments
Yeah,
of which they were now in charge.
I don't think it was deliberate. You know, it's not like we'll ignore the TRC and do the other things. It's that they were so preoccupied with that, that the issues of the TRC for some departments which are far from it didn't focus on it. I think it's the security cluster in particular that got involved, and if it comes to grants and other things, it also involved the social cluster.
And then in paragraph 24, you deal with the security cluster.
Yes, for those whose departments were directly affected, especially the justice and security cluster, they got seized with the complexities of issues they had to deal with related to the post-TRC matters. I must state that as I was not participating in those cluster meetings, I would not know about all the issues they dealt with and how they dealt with them. Later, in our restructuring of government, I became the chair of FOSAT, which was a forum of directors general. So later, you were able to see what's happening in the various departments, but at the beginning, there wasn't such a structure. And in 25, the part I got involved in relation to the post-TRC matters as the Director General in the Presidency and Secretary of Cabinet was in discussions relating to the magnitude of the grant, that's why I was referring to it, to victims as defined by the TRC. The cases of people who were denied amnesty in terms of the TRC Act, and those who did not appear at the commission. On prosecutions, guidelines were developed. I realized when I read backwards that the guidelines I'm talking about, there were more complexities in the security cluster in the ministers I was not involved in. But these particular guidelines were developed after the TRC report, and President Mbeki had to go to Parliament to say what they're going to do with the TRC issues. And the guidelines were developed to allow a possibility for those who were prepared to disclose what they did, to arrange for plea and sentencing arrangements, to dispose of their cases. Affected victims had to be involved and consulted. This is the approach I used in my poisoning case.
Reverend, if you could give me a second. Chairperson, I see it is just after 11 is just a convenient time for the tea
Yes.
journey.
We'll adjourn and reconvene at 11:15.
As you please, Chairperson.
Thank you, Mr. Soni.
Thank you, Chairperson. Reverend, we had just finished with paragraph 26, but can I ask you to please turn over the page, the previous page to paragraph 21, where you set out some of the reasons that the TRC recommendations were not acted upon. And in the last sentence, you say that part of it was due to what you called the political complexities of the time. You'll see that on the top of page 1909. Then if you turn to page 27, which is the paragraph after the one you've just read into the record, you deal with the political complexities again. Will you deal with that now in your evidence?
Yeah, paragraph 27.
Yes.
The political complexities which bedeviled the prosecution of perpetrators of gross violation of human rights related mainly to the need of the old order to protect its commanders and foot soldiers, especially those who were at the forefront of committing these dastardly acts, and the equalization of violence in support of apartheid system and armed resistance to end the apartheid system. There were threats that if the apartheid order operatives were charged, they would also charge particularly members of the National Executive Committee of the ANC, especially the list of 37 that did not get amnesty in terms of the TRC Act. There was a story that the old order operatives had files of minutes of the ANC NEC in exile, which they would use to prosecute leaders of the ANC. I mean, basically they were saying, yeah, there are people who didn't get amnesty from the apartheid operatives, but the 37 also didn't get amnesty. And I mean, just for record, is that the approach of the ANC was to go and take responsibility for what their operatives were doing. So you don't have to bring them in. We take responsibility. They thought it was the easiest way to deal with those cases, except those, of course, who committed crimes which were not political. So that's what I'm dealing with in that paragraph.
And then in paragraph 28, you say that referring to the above.
Yeah. In the light of paragraph 26 above and the fact that we ended up with a political settlement, there was a view which was not codified, and I use that word codified deliberately because it wasn't an official position that's adopted, that we should let sleeping dogs lie to avoid destabilization of the new democratic order. So there was a view. Among those who thought this like this, as I have said in my book, there was not much appetite for looking back. I think there was a view that we have reached a political settlement. We shouldn't do anything that will destabilize the new order. There's one case where I got affected because there was an intention to prosecute P.W. Botha, if you remember at that time. He had said things that he shouldn't say, and their feeling was it's just going to destabilize the country. This man is sick, and he was about to die, and don't destabilize the country. There was a view like that amongst some. It was my observation in paragraph 29
Yes.
that some within government and the ruling party felt that we should close the post-TRC matters and do nothing further. They reasoned that by continuing with the prosecution of these matters, you run the risk of destabilizing the country. This was based on their appreciation that while the perpetrators of gross violations of human rights were afraid of being prosecuted, they were themselves prepared to arrange for those on the side of the liberation movement, that is, those who commanded or were involved in MK operations, to be charged as well. In respect of this issue, both those from the old order and those from the new order were in agreement. They wanted to let the sleeping dogs lie. I think it's,
Ka Setswana Sesotho ba re ska tsosa diletse.
yeah, it gets on. I think there was, what I would like to say is, I mean, there are those who simplify this matter to say you could have done this, you could have done that. But if you were in that situation at that time, where they would say they are planning to arrest the president because he was part of the National Executive Committee, he didn't get amnesty, and if you prosecute ours, will prosecute the others, and vice versa. There was that tension. I mean, there was a moment where I expected that they would try that, and that would have cost quite a sin. I mean, it's like trying to go and arrest a president with security. It's a problem. But remember that the prosecutors were mixed, the old order and the new order, and there were old order people more than the new order in the prosecution authority. The police the same. They had interests, and so we had to manage that situation.
Now, you point out in paragraph 30, Reverend, that this view was not only not universally held, but it had moral flaws in it, and you deal with that in paragraph 30.
Yeah, of course, the problem with this position was that there were many South Africans who still saw themselves as victims, rightfully so, and wanted to know what had happened to a next of kin who had either disappeared or died mysteriously. There were still people looking for the bodies of their loved ones, or graves or places where they might have been buried or dumped. In 31, I say I must put it on record that I was one of those who wanted to know, in my case, about the poisoning. I could not be dispassionate about it. The reality is that there was unfinished business of the TRC that could not just be swept under the carpet. And in respect of the prosecution of the perpetrators, paragraph 32, in my case, those who had poisoned me, some feared that the enthusiasm of urgency with which certain members of the prosecution authority wanted to arrest and charge the 3 police officers who had been identified as being involved was part of a strategy to precipitate action against some of the leaders of the new government, especially the 37 I've referred to earlier. Such a result could be achieved in the name of equality, namely by balancing people to be charged between the perpetrators and gross violations of human rights on the one side and the apartheid regime and ANC leaders were involved in or who commanded the war of resistance against the apartheid regime on the other. And I continue in 33. There was in fact a heated debate between some NPA officials and the command of the police about this matter, as there was an indication that some within the NPA were planning to arrange for the arrest of 37 who had applied for amnesty and didn't get the amnesty. But their application did not fall within the TRC framework. I think the history is recorded there. And on that basis, the application was not accepted. One of those whom they were allegedly intending to arrest was then President Thabo Mbeki for being part of the NEC. I've said this before. Some in 34 believed that those seeking to have the 37 ANC leaders arrested wanted to create a crisis that would force the ANC leadership to back off from the post-TRC cases that fell under the category of unfinished business of the TRC. Others wanted to prosecute people for the sake of it without considering the implications thereof, particularly because of the special circumstances of our transition from an unjust racist system to a just and democratic society. There were, at the time, many conspiracy theories going around. And you can understand that because, I mean, we were together with the people who fought us or we fought. And there were many conspiracies. And it was a bargaining issue to make the new not to charge the old. If you charge them, there are consequences, type of approach. It is against the broad and general backdrop that I have summarized above that I tend now to deal with specific matters relating to the prosecution of those who were involved in my poisoning. I need to indicate here that you'll see from my case, indicate that there was also a fear that the rush to charge people was charge them and without sufficient evidence, let them be acquitted, and it ends up there. And you'll see in my case that I dealt with myself. I was resisting that approach, which won't give me the information I want. You can charge them and lose the case. You don't get the info. I wanted an approach where I get the info, and that's why we stretched it to the limit in my debate with Advocate Ackerman, who was the person I had to work with.
Now, Reverend, the next part of your affidavit deals with the steps you took to ascertain the facts relating to your poisoning. Up to now, and I just want to conclude this part, you've sketched for the Commission the entire pre- and post-TRC processes that were developing around you and your observations on them, and possibly why there appeared to be a coolness towards prosecutions. Would that be a fair summary?
Yeah, it was like a combustion chamber, if you were there. It was like a combustion chamber. You were not sure who's planning what.
Yes.
And I mean, even if you integrated the intelligence services, the agents still reported to their former on both sides. Even
Yes.
within the ANC, there were agents who were still reporting to their commanders who are not in that department. So the uncertainty was huge. The risks were great. And that's why I call it lots of conspiracies. Yeah.
Yes. Can I just, and I know it's not contained in your statement or in your book,
Yeah.
as I understand the philosophy behind the whole TRC process was there would be genuine reconciliation among the warring factions and the people who conducted that war.
Yeah, that was the intention, but I mean the word reconciliation became a victim here. We focused more on, well, when I say we, I'm generalizing, yeah, we focused more on getting the truth, but that did not lead to reconciliation.
Yes.
So people use the TRC for getting out of it much more than getting reconciled. But you'll see my approach produced that at the end. Maybe it's because of my religious perspective and the way in which I looked at things, where I would even promise that if you gave me the information, I won't pursue charges against you.
Yes.
And in my religious tradition and my practice, which I don't impose on any activist, is that I've forgiven you in any way. That's why when Flock came to me, I said, I forgave you, so I don't need to do what you are asking me to do, because for me, forgiveness, it's the way of healing. When they cause you pain, you become bitter, your health gets affected, and they are busy having a bright face and enjoying themselves, the perpetrator.
Yes.
And I didn't want to be a victim
Yes.
of the perpetrator or a prisoner. So I was above what they were doing, but that was the intention, yeah.
Yes. Can we now get to the poisoning itself? And you've given some details of it,
Yeah.
but you deal with it in the next section of your affidavit, starting with paragraph 36.
Yeah.
Just before we deal with it, I want to emphasize this point, which only occurred to me when I was preparing for the leading of your evidence. The steps you took to ascertaining the truth started long before even the TRC process was officially accepted as a mechanism to get out of our past.
Yeah.
All right, I just thought I should emphasize that, and then you could then tell the commissioners how this whole unhappy and sad episode or chapter in your life unfolded
Yeah.
at paragraph 36.
I could summarize this story because it's factual and it's in the
Yes,
record.
yes,
Yes.
yes.
I mean, just for record, the institution of the poison, I don't like calling it a poison because a poison can be anything.
Yes.
But these are organophosphates chemicals which are meant to kill. And so I had been banned from entering Namibia because I had to go to Namibia to support the churches there before the 435 resolution.
Yes. This is the United Nations 435.
Yeah.
Yes.
I got intercepted at the airport not to fly, and they gave me a banning order. I'm still looking for anybody who had such a banning order from South Africa to enter Namibia. And so when the resolution 435 was adopted and the UN moved in, I thought that order does not apply anymore. And I got to the airport with Bishop Buthelezi at that time, and they allowed us through. But according to the evidence in the plea agreement, I don't have to speculate about it. They pulled out my baggage, instituted those chemicals, and they chose the item that rubs against your body. And we guessed about whether it's the handbag or or radio, and they used the underwears, 5 of them. They put that in there. So that's where it hits me. The plan was, I arrive in Namibia, sleep over, we woke up 5 o'clock, drive to the north, and the calculation was that this chemical would hit me when there are no hospitals in the far north, far from hospitals, so I would die there. Nobody would have known why I died there. Fortunately, yes. If you don't want to be spiritual, you'll say, as fate would have it, you know. And for me, it's God's, intervention. It hit me about 20, 30 minutes before we passed the last hospital. And by the time I arrived at that hospital, I was like a lump of flesh. So what it does, it dislocates you completely. And you can't lift your arms within an hour. So I don't need to go through that particular detail. Then I came back, I was attended to, I recovered, and then I went to the US, as I've indicated to you. And I got attacked 3 times before, and went into the intensive care unit 3 times, Wisconsin Hospital. And I've never forgotten this. It's a student specialist doctor who picked it up the 3rd time I arrived there, and that this is actually an equinophosphate chemical, and they sent it to California to be tested. And they proved that it was. So the question was, how do I go back home? Because it used to hit me every 30 hours or so. So those are details now. So my dear wife here, who's in here, had to go with the president of the university there. It was Donna Shelela, who became Secretary of Health, to go and buy me new clothes and take away. FBI took all anything I had and went into new clothes. And then I never got hit again. So that's the detail which I think I just wanted to summarize. In 37, it's after returning to South Africa from the United States, I appealed to the apartheid government and the public in general to trace and identify the perpetrators of the Dastly Act. By that time, I had information that there were 3 laboratories, as you have said before. However, although the police took statements from me, nothing happened.
Can I ask you, Reverend, you say you made an appeal to the public to come out with the facts. How was that appeal made?
Well, it was a press conference, I think, when I arrived, because it was a major public issue. And I made an appeal. I was saying those who are involved, should come out and say it. Those who know the laboratories. We had our own way of investigation, but we're not government, so there's limitations. We couldn't arrest people and question them, but you had to go the soft approach. But there's nothing happened. The police took a statement and did nothing.
And thereafter, at paragraph 38,
Yeah.
you indicate the further steps you took.
Yeah, thereafter, whilst the concept of setting up the Truth Commission was being discussed, I seized an opportunity to call on and encourage those who were involved in or had information about poisoning to take a bold step and make disclosures. What was important was the truth about who had carried out the operation. I took the matter further based on my Christian faith and said if they were willing to confess their deeds, I was prepared to forgive. Sadly,
Sorry, Reverend, can you perhaps give us the year around when this happened?
in terms of, at the beginning of 38, whilst the concept of setting up the TRC was being discussed, I took that opportunity. So it would be before, because I arrived back, it would have been around 89, I think, 1989.
Yes, you left for Namibia in April 1989.
Yes, yes. And I came back, went to the United States, came back around June, July.
Yes, I think that's sufficient.
And yeah, and then the press conference happened immediately. So it was before the NEC was unbanned and all the other liberation movements. It might be possible that some of what I'm speaking to in 38 combines the before and after,
Yes.
but it really doesn't matter. The point is that I made an effort. The advantage I had, of course, which is what you were talking about, is that I was a public figure. I would say it in a press conference and it would be published. An ordinary person would not have had that possibility. I also do say in other writings that if I was not having the profile I had, I would have died in Namibia. And I didn't say what saved us. What they didn't calculate is that we're going to stop and have breakfast and delayed. Whilst that chemical is working on you, delayed arriving where they thought I would die. And that was just an ordinary breakfast, resting, and started driving again. So even the people in Namibia, the assistant secretary of the Council of Churches who was with me, they were all investigating. And my brother was in exile with the ANC. They also investigated from the ANC side in exile. So it wasn't just my lone exercise.
Now, Reverend, what was the response to your pleas for the truth to be outed?
No, they didn't come out. I think it's only in paragraph 39.
Yes.
Sadly, I must record no one came forward except for Paul Erasmus, who revealed in a newspaper article that he was responsible for putting me on the death list of the apartheid security police on the basis of instructions from his seniors. He said he had joined the police when he was 18 and believed everything he had been told about black people, including that we were dangerous and that whites had to do everything possible to suppress us. He expressed regret about what he had done. I managed to talk to him over the phone. I talked to the journalist who reported about the story, asked to be linked up with him. And then I talked to him. I assured him that I had forgiven him and that I was prepared to meet with him personally. I had disclosed that he had certain knowledge about my poisoning.
He had disclosed.
Yeah, he had disclosed, sorry, and about the persons responsible for it. Unfortunately, Paul Erasmus was placed in a witness protection program, and we could not take this matter further. I've never understood why, if he was put under a witness protection program, the investigators couldn't reach him, because they should have a way in which and they told me that they can reach him. Nevertheless, I did get some information from the prosecution authority, because I engaged them, some of which would have come from Paul Erasmus. So the information I have about him also came from Paul, through the prosecution authority that talked with Paul Erasmus. But I would not let the matter rest in 40. In my quest to ascertain details relating to my poisoning, I wrote letters too, and I spoke about that, so you can see the list. Former President de Klerk, Minister Flock, Commissioner of Police, Johan van der Merwe, the Minister of Defense, Deputy Minister of Defense, Rolf Meyer, former Surgeon General Niels Knobel, and former Army Chief General George Neering. All denied knowledge about this poisoning. I record that I also wrote to members of the new government as a result of the various processes I initiated, like the Minister of Police, it was Mufamadi at that time, and because I thought they also would assist. I gathered enough information to lead me to the police officers who were involved in the actual operation to poison me. I identified them as Christopher Luodevikas Smith, Gert Jacobus Louis Hosea Otto, and Hermanus Johannes van Staden. And their code was Smith Otto van Staden. That was the code. So you would have thought it's one person, but we managed to decode it. In 41, when the TRC Act was passed providing a legal framework for perpetrators to apply for amnesty based on voluntary disclosure, I repeated my call again for information relating to my poisoning, but no one responded. Those who appeared before the TRC to apply for amnesty chose to deny any knowledge of my poisoning, apparently because it would implicate many people at the top echelons of the apartheid security establishment and the political leadership. Nevertheless, some bits and pieces of information helped me to strengthen my suspicion that the apartheid security forces were involved in my poisoning.
And then you got a response from an unexpected group of sources. These were the scientists who...
Yeah, the scientists.
Yes.
Yeah, I'm already Director General in the presidency, and the scientists who were responsible for producing the lethal toxic chemicals and biological substances used in poisoning me responded by invitation to disclose their involvement. It was a very interesting but frightening experience. I welcomed them. They were led by Dr. Andre Immelman. They visited me at the union buildings and expressed regret for participating in the production of the legal substances that were used against me. And I may add, probably against others as well. That's my point that concerns me greatly. Having met the scientists and following the window of opportunity opened by the statement by the President in Parliament about post-TRC matters, which asked the NDPP to negotiate indemnity from prosecution in terms of existing law for those who made complete disclosures to the NDPP. I believe that this presented an opportune moment to communicate directly with those who were involved in my poisoning and to appeal to them to disclose their involvement. With all the information I now had at my disposal, it became clear that evidence was building up against the perpetrators of this callous act, which could lead to their arrest and charges being preferred against them.
Now, the perpetrators you are talking about are the three,
yeah,
what later became known as the 3 foot soldiers.
Yes.
Smith, Otto, and van Staden.
correct. And in 44, thereafter, with the help of the NPA, I addressed letters to the 3 police officers involved, asking them to disclose what they knew. I reasoned that I should use the NPA because it was in contact with the lawyers of the perpetrators. And because I did not want them to say I had threatened them, so I had to handle it with care. By the way, I didn't say it here. Initially, we were told this, we got information these 3 police were in a farm in the Eastern Cape. Now, if you are not police, you can't go to that farm and find them out. So I had to try to be as legal as I could to deal with this matter. In May 2003, through the media, I wrote an open letter to fellow South Africans in which I said that telling the truth and giving information about what happened to victims and those who disappeared or died during the days of the apartheid system is critical to the process of reconciliation, healing, and transition to a democratic society. I also made the point that those who were still imprisoned by their past deeds should come forward with information so that we may proceed with the building of a new, more humane and peaceful South Africa for all South Africans. It was really an appeal as a process of building up a new South Africa. In addition, I made public my offer to waive my rights to sue for damages or seek prosecution, to make it easier for the perpetrators who had failed to take advantage of a TRC process to acknowledge culpability or involvement in apartheid-inspired attacks on me. In 46, in addition, on several occasions, I wrote to the 3 police officers involved making the same plea. Despite these repeated efforts, I regrettably received no reply from them. However, in 47, as more and more evidence was coming to the fore, preparations were being made to arrest the 3 police operatives. It was the imminence of the arrests in the latter part of 2004 that sparked the flurry of activity. Flock and Van der Merwe entered the fray as they believed in taking responsibility for those who worked under their authority or command. They interacted directly with the NPA on behalf of the 3. And when they realized they were not making progress and time was of the essence, they started a line of communication with me based on my letters and my offer.
What was your position in regard to them coming forward to indicate their involvement? You deal with that in paragraph 48.
Yeah. In paragraph 48, my position was simple and deeply personal. I don't want to impose it on anybody. Just disclose to me the story, then use the channel the president announced by presenting the disclosure to the NPA, which would be expected to facilitate a plea bargain arrangement to close the matter. Their concern, however, was that there was no legal provision and framework for what the president had announced, and that it left the perpetrators vulnerable, as there was no guarantee that the arrangements with the NPA would not result in their imprisonment. Besides, a plea bargaining arrangement had to go to court, but this exposed them to the risk that a court could make a different ruling that could also result in their persecution. I must say that that debate was quite intense, because what they wanted a process where you would guarantee that they will not go to jail. And the plea bargaining arrangement, which the president talked about, didn't give them that guarantee. They wanted it from me as well. I said, I don't have powers to give such a guarantee.
Yes. Reverend, on that score, in regard to the requests or demands for that guarantee, were those communications made to you or through their lawyer or through the NPA?
You remember, they started with the NPA. Yes. They couldn't get that. They thought talking to me directly, because I've said they will be forgiven and etc. Yes. I could give them that guarantee. I said I have no legal basis to care. Yes. When you do plea bargaining, there's a risk. You could agree and the judge could make a different finding. And so in 49, I say, for these reasons, they preferred their original position, which they had presented to the NPA and the political leadership, particularly F.W. de Klerk and Thabo Mbeki, namely a general amnesty. However, they acknowledged that this was a non-starter, as it had been rejected even before the TRC processes. So you couldn't do it the way in which they wanted. They didn't go to the Truth Commission before. After, the arrangement is still disclose and then make a plea arrangement. That was the legal route they could take. In 50,
Yes.
another concern that they had was that any disclosure by one person about a particular case was likely to implicate others, and one could then be forced to be a witness in other cases that may be brought to court. They were worried about exposing or giving evidence against one of their own. One could not miss the point that there must have been a pact between the operatives that they would not sell out any of their own or expose them to risk. This illustrated to me the multiple layers of lying and denial in place. This, in my view, was to ensure that the line of responsibility for such processes as my poisoning was not traced to the cabinet, including then President P.W. Botha, who chaired the National Security Council. Just for record, they made this decision against us in that National Security Council, formerly chaired by P.W. Botha, and agreed the army will deal with those outside and the police. And Van der Merwe, I think, is the one who was present in that meeting and then went to brief Minister Flock, I think, and then they appointed the 3 police to deal with me.
And this is Flock and Van der Merwe.
Yeah, the Van der Merwe was the commissioner of police. My reading is that when Van der Merwe was in that meeting, he was not yet the commissioner. He became a commissioner after that, but he was the police representative in that council,
This is in the National Security Council.
the National Security Council. So the president of the country was implicated in this, and all those who sat in that council, but nobody investigated that with all the information that we had about it. In 51, in the result, as often happens, the sad reality is that it is usually the foot soldiers who were the first targets when information comes to light, because they are the ones who carry out the action. So they would become the first one. This was what initially also happened in this case. It was this police who I was saying, Smith, Otto, and van der Staden, who were the first targets. Be that it may, however dastardly my poisoning, I have to respect Flock and van der Merwe for not abandoning their foot soldiers. It was quite extraordinary because the investigation didn't show they were involved. But once they realized the police were going to be arrested, he came with van der Merwe and said they can't abandon their foot soldiers like some of their colleagues, especially in the military. They have never done that before. At a critical moment when the 3 policemen were at risk, for Flock and van der Merwe came out of the woodwork, took off their masks, moved from their strategic lies to protect themselves and their foot soldiers, to declaring solidarity with their foot soldiers. They admitted what they had denied all along and were prepared to be charged along with their underlings. It is for this reason that they started the negotiations with the NPA, failing which with myself. This is in stark contrast, as I've already said, from how the defense force, up to now, we don't know who was killed by the defense force using these chemicals. In my discussion with Flock 52 and van der Merwe, my discussions with Flock and van der Merwe turned into a kind of negotiation process about how Smith, Otto, and van Staden could respond to my call without opening themselves to prosecution. Their lawyer, Jan Wagenaar, was also involved.
Can I ask you to stop there for a moment, Reverend?
Yeah.
Did you have any communications with Mr. Wagner?
Yeah, I think there's a point at which I directed a letter to him because I was told he's their lawyer. But I had no way of doing it directly, and I went through the prosecution authority.
Oh, I see. So
Yeah.
you didn't communicate directly with him?
That letter was directed to him,
Oh,
but via the prosecution, because the prosecution authority knew how to reach him. I didn't.
oh, okay.
But I also wanted to go through the lawyer initially rather than directly with those three policemen because I was careful not to be seen to have threatened them in any way because that was critical for me. I wanted them to come voluntarily.
Wagner, or the evidence before this commission, is that Wagner had told Advocate Ackerman that you are wasting your time with these prosecutions because a deal has been struck that there would be no prosecutions.
Yeah.
Are you aware
Yeah,
of that?
no.
You
I
better
can't.
say a deal has been struck by whom?
Oh, sorry, you're quite right,
Yeah.
Commissioner. It was a deal between the ANC and the police and defense force hierarchy, or the old police and defense force hierarchy.
Yeah, I don't want to talk about Wagner because I wouldn't have direct evidence. But I mean, he was the key person who was, if you tracked any perpetrator, you ended up with Wagner. And so he was part of the strategy to make sure their people are not prosecuted. And I knew a lot about it, but I mean, I don't have evidence. You know, intelligence is not evidence. You have to produce evidence. And so my approach was use the NPA. And I now know that there was a debate amongst them. When they wanted to charge those policemen, I think it would have been 2004.
November 2004.
Yeah,
yes.
around 2004. My worry was they will charge them to release them. Yeah, you see, if the old order charges them, people who were in the old order, they could charge them to release them. So the prosecutor could go and say, this is the only evidence we have, and then they get acquitted. I was not interested in a rushed operation to charge them. I wanted to make sure we get the information from them.
Can I ask
So
you to,
for me,
oh, sorry.
it wasn't, some people think I resisted that they be charged. No. I wanted them to be charged because even if I had enough information, let's call it intelligence information, I couldn't go to public and say, these people poisoned me, they will sue me.
Yes.
I wanted, when they go to court, they must put it on record. Now I can talk about it because it is in the plea agreement
Yes.
document. That was my target, and I was worried about the rush and concerned that I wouldn't get all the information. And I think my approach worked because I got the information.
Yes. So, in 2004, when the initial proposal be made that they be charged after being arrested or taken to court after before being charged, your view was that let's get all the information before we finalize the prosecution process.
I could dictate to the NPA,
Yes.
you know, the prosecutors. I couldn't dictate to Ackerman,
Yes.
but I was suspicious that he may do it as part of their strategy to negate this. And I didn't trust them. At the point when Flock and Van der Merwe came to me, I collected more information from Flock and Van der Merwe because they wanted to get help. So I said, no, I can't help you. But if you give me the information, then you can go and do plea bargaining. And that's why, I mean, later in the statement, we get into conflict with Ackerman. Because he got to know that I have more information than they had.
Yes.
Or he just wanted to punish me because he demanded that I surrender all the information I got from Flock and Van der Merwe, and I said, no, it's not my responsibility.
Reverend, we're going to come to that because all of those matters are dealt with in your letter to
Yeah,
Minister Mabandla
Yeah.
subsequently. We'll come to that because I want to deal with that in some detail. But just coming back to the matter before the court, were you aware, or did Mr. Ackerman tell you that Wagner had told him that there is this deal between the ANC and the old order police and defense hierarchy, that there would really be no prosecutions? We're all wasting our time. That's more or less what.
I really don't remember me having a debate with Ackerman about that matter. I think Ackerman was determined to charge them. The only concern I had is to what end? Yeah,
Yes.
what's the strategy? Because there's a strategy. Indeed, what what is it?
Wagner.
Yeah, that lawyer, he was part of the grand strategy designed before the negotiations to say if we get there, we're going to have to negotiate that nobody gets prosecuted. That was their strategy, all of them.
Yes.
And so I wouldn't be surprised he talked to Ackerman to dissuade him from charging the people. On the other hand, we were suspicious that Ackerman was using the case, my case, to precipitate the crisis so that they can then go and arrest some of the ANC leadership. So it's in that, that's why I say you needed to be there to actually deal with this difficult environment. Yeah.
And that would come about on the basis of that equality
Yeah.
issue that you talked about earlier and that Commissioner Como brought to your attention, that if you are punishing the perpetrators of
Yeah.
abuses, then you must also punish the liberators
Yeah.
where something went wrong.
Yeah, and their weapon was the minutes of the African National Congress, which obviously they had infiltrated, and they got the minutes from Lusaka,
Yes.
and they would then use minutes that talk about deploying MK operatives and etc., and the consequences of that.
Let me ask you this, and it's just occurred to me now. You talked to Commissioner van der Merwe, former Commissioner van der Merwe.
Yeah,
One of the pieces of evidence that was given here was that Commissioner van der Merwe had indicated that he had a docket in respect of the members of the ANC NEC relating to the command structure in Lusaka.
Yeah.
Did Commissioner van der Merwe ever say that to you?
No. I think Commissioner van Beven and Flock were there to plead. I don't know why they thought I can move the whole system to their favor. They were pleading for a way
For
of
leniency.
getting over this without their foot soldiers going to jail. I think that's what they were talking to me about, not the strategy about the ANC, the generals and all that. I may know about those conspiracies on the other side, but they were not discussed in my case.
In your
Yeah.
presence.
So they were very guarded.
Yeah, I mean, I pressed hard to get the truth from them, but they were very guarded. They wanted a settlement without going to jail. I think that was their determination. And when they failed with the NPA, they came to me. But I handled them in a way that they gave me more information
Yes.
without threatening them.
Yes.
Because my intention was not to fight with them. It's how was I poisoned? How did it happen? Who was responsible for it? And I was able to get the information.
And neither Flock nor van der Merwe said to you at any stage, but look, you know, if you're charging us and our foot soldiers, just expect that the ANC leadership too will be charged.
No, they didn't play that game with me, I think. I mean, they knew that it wouldn't work with me, actually. They didn't come with conspiracy theories. They wanted a way out, and they were not going to be charged. It was going to be the three policemen. They decided to join them because they said we instructed them, and that's why we are.
Oh, I see.
Yeah.
Okay. And that's why you have so much of respect for them,
Yeah.
because they came out of their woodwork.
Yeah, people don't understand it, how I can have respect for Flock.
Yes.
But they came out. They made it quite clear to me. He said to me, I'm not going to allow my foot soldiers to go to jail when we are the ones who instructed them to do it. So they joined themselves into the case, in a sense, the way I understood it at
Yes.
that time. And that's why I respect them, because we could have got the three policemen prosecuted without them getting involved at all. Yeah.
Now, then, Reverend, you deal at paragraph 52 with the fact that, well, you've dealt with that already, that it was a negotiation process. And then you say in paragraph 53 there were parallel discussions that were going on.
Yeah.
And what were those?
Parallel to this discussion was an ongoing dialogue between Flock, van der Merwe, and Wagner on the one hand, and NPA, particularly Advocate Ackerman, who was responsible for the case on the other. There was also a raging debate between government and the NDPP about a prosecution of policy to deal with the unfinished business of the TRC cases. That's the principles for prosecution of TRC-related matters. And this was in line with President Mbeki's speech in Parliament.
This is the April 2003 speech in Parliament.
Yeah.
Now, you say there was a raging debate between government and the NDPP. Who from government would have been engaged in that debate with the NDPP?
See, I wouldn't present to you evidence because I wasn't involved. But I knew that there was a raging debate
Yes.
I mean, being in the presidency, you do get to know, but you don't have first-hand information. So I would want to talk about something I don't have first-hand
No,
information. But there was about the guidelines. There were people who were saying, but they don't meet the legal muster, those guidelines.
Yes.
You know, there were those who were saying that. Others were saying, this is the only way in which you can get the information. Because it was a continuation of the Truth Commission in another way.
Yes.
Yeah, to say, give us the information, do plea bargaining, that type of stuff.
Yes.
But the Ackerman and others, I think, were of the view that those guidelines don't pass the muster. At least I can say Ackerman because he engaged me very angry in my office.
Yes.
And it didn't end well. I said to him, you can go. He wanted to charge me, to force me to give him the information. And I said, apartheid failed to do it, security police. You won't succeed, try it. So it didn't end well, but we had a witness. I don't remember the prosecutor who was with him.
Mr. Mahaka.
Yeah, he had somebody in the room. And I told them, I'm not going to be forced to give you information. If you want to be helpful, we can talk about it, not force me.
Yes.
Yeah.
We come to that in a moment when we go through your letter with the to
Yeah.
the minister.
Yeah.
Now, I want to then go to the fact that after this quite elongated process starting almost in 1990, about 1990, in 2003 and in 2006 the prosecution takes place. Because that's when the prosecution...
2007.
2007,
Yeah.
sorry, yes. Now, in the next section of your affidavit, you deal with the charges against the accused. They are there, but if you could just summarize what's contained in that section. And then we know that the next section is your dealings with Ackerman. We can deal with that in a moment. But let's just deal with the charges against the accused.
Yeah.
They are set out in in Annex
yeah.
A.
Yeah.
Yes. But you summarize them.
Yeah, I deal with that matter in paragraph 57. The main charge against the accused was that of attempted murder, it being alleged that on or about the 23rd April 1989, that's the day I went through the airport, at or near the vicinity of the Jan Smuts airport, the accused unlawfully and intentionally and in furtherance of a common purpose attempted to murder the Reverend Frank Chikane by way of administering a poison, to wit, para-oxon, to his clothing.
Yes.
By the way, the FBI in their investigation, the scientist of a police person, FBI, woman who did the investigation from my clothes and blood samples and all that, and they reached the same conclusion of that particular chemical.
Can I just ask, because I don't think this has emerged directly, as I understand it, the way they got to your clothes was they intercepted your bag at what was then Jan Smuts airport while you were on your way to Namibia.
Yeah. When they gave me the order not to go to Namibia initially, they stopped me before I luggage my baggage. And gave me the order in front of the desk where I was going to check in. This time they allowed me to check in. And they do say themselves that they had arranged for my baggage to be taken out of as they were passing to be delivered wherever they have to put in the plane, they would pick up my baggage, put it in a particular room, and the person who picked it up would leave. Then the 3 policemen would come, open the bag, put the chemicals, and left, and the bag was taken and put back on that, and then it went to.
And you had no idea that that
No.
had happened?
No idea. At that time, I suspected they could stop me from going to Namibia,
Yes.
but they didn't stop me. And, but I wouldn't have suspected. We had no information they would do that to my baggage.
Yes.
But they've said it themselves, so it's not
Y-
speculation.
Yes. Yes.
Yeah. And in 58, I need to also record the following. First, that the accused were charged in the alternative with contravention of Section 18.2 of the Writers Act. And I listed there together with Vota Basson, Andre Imelman, and persons unknown to the state, namely conspiring to kill Reverend Chikane. Second, all these persons also faced further charge under account 2, namely conspiring to commit the crime of murder of persons unknown to the state. And I must say that that second count, which they dropped, was strange for me, because it means they knew there are other people
Yes.
and they didn't actually pursue that matter.
Can
I, in turn, summarized my interaction with Advocate Ackerman, who made what was a difficult and painful process even more painful. So in my interaction with Ackerman, yeah.
I'll come to that in a moment. I just want to go back to paragraph 58. Do you know why Vota Basson was not charged, or why the charge against him was dropped?
Yeah, but that's what surprises me. Actually, when you read the plea bargaining, they put them on the same,
Yes.
Vota Basson.
Yes.
But they charged, but you remember they charged Vota Basson for other matters.
Yes.
And they wanted me to be a witness there, which didn't make sense. But at that stage, it's now my suspicion. At that stage, it looked like they were doing scores amongst themselves, the old order. Charge Basson for corruption. I think it had to do with corruption,
yes.
and etc.
Yes. Fraud as well.
Yeah, so there was a battle between themselves, who got money and the other one didn't get money. And I can't speak to that because I don't have first-hand information. But there were enough people. There's is it Smith in that plea bargaining, who was now the chief responsible for this operation.
This is Bassi Smith.
Yeah, they should have charged him as well. So if you took that plea bargaining stuff and investigated at that time, there was enough evidence based on the confessions of the 5 in this case.
Yes.
That's why I was saying, if you got one to confess, then they implicate others. That's what we thought it would happen. But they implicated others and no charges were preferred.
The or coming back to paragraph 58, the Andre Immelman is the scientist, one of the scientists who came
Yeah,
to the union buildings to apologize to you.
that's it.
And he had, in fact, confessed to you that he'd been involved. He'd been one of the people who had
They were
made the poison available, or the chemicals available.
Yeah, he admitted, he didn't admit acting against me, but they admitted they produced those offensive chemical instruments, which means they packaged them in a way that they are meant to be offensive.
Yes.
You know, the way they were packaged. Either they put them in a pen or this. There were other methods they used. So the scientists did the packaging. The police came and got an order to say, I want this type of a chemical. They may not know what it is. In my case, they say, we want one that kills. So it's in their confession there.
Yes.
And they were given this oxyon or whatever they call it. So he was there.
Okay.
Yeah.
Can we then go, Reverend, to the section of your affidavit where you deal with where you address your dealings with
Ackerman.
Advocate Ackerman? Yes.
Yeah. As regards the prosecution of the accused, I had several discussions with Advocate Ackerman. I record that I found that his approach was a punitive one and not within the spirit of the post-TRC processes and the president's call, including the muted prosecution principles related to the unfinished business of the TRC. In contrast, Ackerman's approach was a straightforward prosecution that would make me a witness against the perpetrators. Now, I couldn't be a witness against the perpetrators because I was going to then say what they told me.
Yes.
That's how I then become a witness. So I use the information they get from me to be a witness. It didn't make sense to me because that's the information I wanted in any way. In 61, my response was that I was not interested in a prosecution for the sake of prosecution. I was seeking the truth about my poisoning. In addition, I had pronounced publicly that I had no interest in sending the perpetrators to jail and was ready to forgive them. Moreover, at that stage, they had already disclosed much of what I needed from them through Flock and van der Merwe, and already asked for forgiveness from them. Later, he went the extra mile and even washed my feet. That story is known. I refused to get my feet washed, but he said it was for his own, not for me. It was his own. I think Flock went through some Damascus experience after the passing of his wife, 94. And that's another chapter. In 62, the approach set out above, which I conveyed to Ackerman, seems to have caused him to conclude that I was a hostile witness. He went as far as threatening me with Section 205 of the Criminal Procedures Act to force me not only to give evidence against the accused, but to disclose all the information Flock and others had given me. I mean, for me, it was funny that now the victim is getting charged, which didn't make sense to me. This is where our
It would have
discussion...
been a delicious irony.
Yeah. This is where the discussion ended. The Section 205 threat reminded me of the old apartheid days. I was like putting salt. It was like putting salt on my wounds. I dared him to try it and see whether or not he would succeed where the apartheid regime had failed to succeed. At this stage, I knew I was just a pawn in a bigger scheme of things they were fighting about.
Can I just ask you, what do you convey, what was the biggest scheme that you thought was being played out with you as a pawn in the
Yeah,
middle of that?
use my case to precipitate a crisis and achieve their objectives. Yeah, that was my feeling that, and at the same time, my comrades, some of my comrades were saying, but why are you continuing with this case? There were others who were asking me, and I said to them, I have an interest in getting information about my poisoning. And that's why ultimately I went to court alone. And that's why the book says a lone journey. I was alone in that court with a communication officer from the presidency who chose to accompany me in his personal capacity. The court was full of journalists.
But none of your comrades.
Yeah, no, none of them. Because I think at that time the feeling was that you're taking this matter too far. And I said, no. I mean, I'm not interested in sending them to jail. I want them to put it on record so I can use the information. That's what I wanted, and I got that.
Yes. Then you talk about the consequences being dire. Now, you then say you have set out these, I'm talking about paragraph 64 now. You say you set this out in your letter to Minister Mabandla, and you isolate matters in paragraph 64 that are contained in your letter. Rather than dealing with the summary here, may I ask you, Reverend, to go to the letter which is Annexure B to your affidavit. It's the last 3 pages on that file.
It's the Annexure B.
Annexure B, yes.
Yeah.
Can you recognize this letter, Reverend?
Yeah, no, I do. It's my letter. Yeah.
Let's start off with the date of the letter.
It was on the 22nd of October. The case went to court in August of 2007.
Yes.
And after that case, I was really terribly disturbed that there was absolutely nothing that is being done to deal with these cases, because in essence, let me put it personally, my journey produced evidence that was enough for them to do more work, and nothing was being done about it. I thought I must write to the minister to identify those areas which were of my concern. Again, I mean, it's again the advantage I had.
Yes.
I mean, I could write to the minister, even if she took 1 year to respond, but she did respond at the end.
Yes.
But an ordinary victim would most probably not have reached that level.
Yes.
Yeah.
The letter is addressed to Minister Mabandla, and would you read the contents of the letter into the record, Rev?
Yeah, I'm going to struggle because the letters are very small.
Yes, except the last page, which I managed to read. I really struggled with the first 2 pages. Well, perhaps council is asking you to do your best. Hopefully your best would be good enough.
Yeah. Can I hear what you were proposing?
No. Council is in a better position.
Yeah.
Are you
You
not-
want me to read? I can read it.
Yes,
I was just
it
saying
would
the
be helpful.
letters are very small.
I know,
If
I
I
don't know how
had
that
it in
came
my
about.
computer, yeah, but let me read it. It's a State versus Van der Merwe and others to Minister Mabandla. As you would know, the case of those who were involved in my poisoning, namely Johan van der Merwe, Adrian Flock, and the rest of those police, was disposed of at the Pretoria High Court on the 17th August 2007 through a plea bargaining arrangement between the accused and the state. Although I am pleased that we have concluded this matter, I am concerned about a number of issues which I would like to raise with you. And hereby, the government of the Republic of South Africa, meaning I'm raising it with the government of the Republic of South Africa, I hope that you will find it necessary to share my concerns with Cabinet, as I believe that this will be helpful in handling other matters of a similar nature. We're just gone through this, so it should be a way we could learn from it. Yeah. The first point I would like to raise in the handling of this matter by the National Security Prosecution Authority, from my interaction with the relevant officials within the NPA, it is clear to me that the said officials are simply the wrong people to deal with post-TRC matters. My experience with them is that they will not be able to relate to victims of gross violation of human rights or their next of kin with the sensitivity that is required. In fact, they did not seem to understand the nature of the challenge we're facing. Firstly, my court case was used to fight battles between the NPA and the government about the guidelines for dealing with post-TRC cases. Throughout this process, I was left with a feeling that no one, in fact, cared about me as a victim. What mattered were the politics around the handling of the TRC cases and how people would win their battles. As part of the consultative process relating to the case of the Van der Merwe and others, and his assistants visited me. Instead of just consulting me as a victim, he entered into an acrimonious argument with me about the approach to the government on post-TRC matters and the guidelines. From this interaction, it was clear that he was radically opposed to the guidelines as agreed upon by Cabinet and the Parliament of the Republic of South Africa. In fact, he seemed to be more interested in prosecution for the sake of it rather than the management of this difficult post-TRC process. What I detested most was that my case was being used to fight their battles with the government. In pursuit of this objective, a draft letter which was constructed in a manner that would enhance their position in the prescribed forum with other departments was presented to me for my signature. What was more disgusting for me was that when I refused to sign that draft letter, Advocate Ackerman then threatened to use section, I mix the section 204 and 205 that can be corrected, of the Criminal Procedures Act against me to force me to surrender all the information I had received from the information I received from Mr. Flock on my poisoning. I dared him to do so and reminded him that this was tried against me during the apartheid days and it did not work, and that there is no reason why it would work now. He backed off and left. His colleague who was with him is my witness in this regard. Secondly, I was not consulted about the details of the plea bargaining agreement. The NDPP informed me in writing about the agreements for suspended sentences for the accused. My views were not solicited in this regard. In fact, I was not informed about the basis for the plea bargaining arrangement. I only saw the plea bargaining agreement during the prosecution in court. I was particularly distressed by the submission in section E, paragraph, I think it should be 6.3 or 8.3 of the plea agreement, which claims that I was consulted about it and that I was satisfied with the plea agreement and that I did not wish to make a further representation in connection with the matter I'm quoting. The reality is that I could not be satisfied with something I had not seen. Having now considered it, there are naturally a number of issues I have concerns about, which I had no opportunity to deal with. This leads me to the second matter I would like to raise. Failure to consult me before the plea bargaining arrangements were made resulted in the presentation of documents in court which did not only have factual errors, but were politically and philosophically problematic to me as a victim. Firstly, my background is presented as if I was both General Secretary of the Council of Churches and Vice President of the UDF, when in fact I held these positions at different times. Secondly, the plea bargaining arrangement falsely argues that it was the stated policy of the UDF to propagate and support violence for the purposes of rendering the country ungovernable.
Sorry, Reverend, your point there being that was not the policy of the UDF to promote violence.
Yeah, but they can't put a plea bargaining agreement which says this.
Yes.
Yeah, if they talked to me, I would have said, I don't agree with you. By the way, I'm not a lawyer, but I thought that if they do a thing like this, you would be made to do an confirmatory, affidavit that I agree on this. And they didn't ask me to do that. And then there are, where are we now? Yeah, there are these issues, 3 issues I would like to raise on matters of such substance. Firstly, count 2 was withdrawn as part of the plea arrangements. And by so doing, the collaboration between the security police special unit and Voda Basson and his team in producing or procuring the lethal chemicals used, the letters are small, used was not probed further when it is clear from the plea bargaining agreement document that more information could have been extracted. Secondly, there is a reference in the plea agreement document to a list containing names of high-profile members of the anti-apartheid movement struggle who were to be acted against and in extreme cases be killed. And that's paragraph 37. There is no indication that in this matter, that this matter was probed further. The state should be interested, for instance, in the copy of such a list of to determine as to who also was on the list and what happened to them. Thirdly, there is no indication as to what discussions the MPA had with General Bassi Smith and Basson to secure more information about the operations, and it's not clear here. And fourthly, there is no indication that there has been a process to probe the involvement of this SANDF on these matters, and what happened to their list of external targets. The guidelines for the post-TRC cases make it clear that our objective is not just prosecution, but the need to solicit more information about what happened to the victims of gross violations of human rights, especially those who died or disappeared. Moreover, it is to get a better understanding of how the old national security management system functioned to make sure it does not happen again. Although the Van der Merwe and others case assisted me to know more about what happened to me, failure to follow the guidelines and thereby collaborate with other entities of the state, like intelligence services, the police, and the defense force, made us miss an opportunity to learn more about what befell the other people who might have been affected in the same way. Lastly, I found the court itself completely foreign and insensitive to me as a victim. Firstly, the court was completely white, from the judge to the prosecutors, defense lawyers, and the accused. But worse, the proceedings were conducted in Afrikaans without due regard to the victim, especially where technical, legal, and court processes are involved. As a result, I missed the greater part of the proceedings of the court. I am sure that we can make the court friendlier to victims than what I experienced that day. On the side of government, I felt that the handling of the state versus Van der Merwe and others case was left to me as a victim to explain to the public instead of the state or government. No effort was made by government to manage this process or deal with public perceptions about it. No one got involved to make sure that the process achieved the objectives government had agreed upon. Clearly, once the NPA acted unilaterally, the government apparently walked away from the matter. I do not think that this hands-off approach assisted us in any way to achieve the objectives set out in the guidelines. I shall be pleased, Minister, if the government could deal with all these matters. I have raised as well as, the matters I have raised, as well as remedy the situation before another case is dealt with. Yours, it's myself.
Now, Reverend, you might remember we were at paragraph 64 at your affidavit, and in paragraph 64, you summarize some of the concerns that are raised in your letter.
Yeah.
Can I ask you then to go back to paragraph, page 1923, paragraph 64?
Yeah, I say the consequences of this breakdown were dire, including
Yes.
factual errors in the plea and sentencing agreement. Views were attributed to me without any supporting affidavit to ensure their accuracy. I have set out in my letter to Minister Babadla, in which I noted, amongst other matters, the following.
And we've dealt with all those matters.
Yeah.
Can I then ask you, Reverend, to Chairperson, I see it's 1 o'clock, but I'm in the point of nearly concluding.
Yes, you may
May
continue.
I continue? As you please, Chairperson. Also find it, oh sorry, you then say at paragraph 65, you find it necessary to record certain matters. What are those?
I say that while my struggle with the NPA was going on, a campaign was launched from other quarters of government to stop the case without considering my enduring need for a recorded confession, especially on an official court record. Besides, there are still too many, mainly whites, who doubted that a government that claimed to be Christian would commit such an inhuman and treacherous act. Many of those who came to confess to me and ask for forgiveness said they did not know what the government had committed, that the government had committed such acts in their name. That their worst sin was that even when it was made public that government had committed such inhuman acts, they did not believe it. And I need to cite my colleague in the church who led the white church before we united, that he said afterwards he never believed, as I was going to detention and torture and poisoning, he never believed his government could do that, and classified it as terrorists, basically. So this case was very critical to confirm that indeed this is the Christian government that did what they did. I felt caught between the three parties, those who perpetrated gross human rights violations against me, the NPA officials, and the government officials who held conflicting views. Throughout these processes, I interacted with the NDPP from time to time. I also sent the letter to the Minister of Justice to raise my concerns at the end of the case. I also kept the President informed about what I was doing without involving him in the matter. So when it came to this matter, the only discussion I would have with the President is to keep him informed so that he's not surprised I'm going to court and etc. But he didn't get involved in the matter.
Then finally,
The conclusion.
yes,
I have on numerous occasions noted the trauma that has been caused to me, not only by the apartheid state, but also by the manner in which the case against the perpetrators of this heinous act against me was dealt with. As a victim of such an act, I submit that I was entitled to be treated with empathy and understanding. After all, I had suffered enough at the hands of my apartheid tormentors. I hope that what I have set out in this statement is taken note of and other victims of apartheid abuses are not put to the second round of torment. The South Africa that we have created, with all its imperfections, owes all of us at least. That is a value that members of the security cluster, especially SAPS and the NPA, must instill in its members.
Chairperson, that is the evidence that we intend tendering through
Yes.
Reverend Chikane.
Thank you. We'll take a lunch adjournment and reconvene at 2 o'clock.
As you please, Chair.
Ms. Rukoto, any clarificatory questions for the witness?
Thank you, Chair. We have no clarificatory questions for this witness.
Ms. Tambeleni?
Thank you, Chair. We have no clarificatory questions.
Yes. Mr. Mchizana?
Thank you, Chair. I only just have one clarificatory question.
Thank you.
Good morning, Reverend Chikane.
We can't hear you.
Can't
Speak
hear.
up.
Good morning, Reverend Chikane. I would just like to ask if, from your concerns that you raise in Annex JB to the minister, I just would like to know if you've received any responses regarding all issues you ventilated in the letter. Did you receive any response from the minister?
Commissioners, yes, I did receive an acknowledgement. I don't have that letter, so I can't refer to the details. But it was more of an acknowledgement of my submission to her. But I can't say anything further because I don't have that letter now.
I thought you said a year late, or you spoke about a year.
Yeah, she did respond. Yes, respond roughly almost a year later because these issues were like happening continuously, and she responded at the time when she was able to respond to me.
Okay, thank you so much.
Ms. Mtloko, any clarificatory questions?
Thank you, Chair. We have one or two. Good afternoon again, Reverend. Firstly, I think on behalf of the NPA, we would like to apologize for the trauma that you experienced both during apartheid and what you describe during the prosecution of the Van der Merwe matter. So in your statement, Reverend, you indicate that there was political complexities that surround post-TRC prosecutions. Can you kindly elaborate what those complexities were in your views?
Yeah, I do have that paragraph that deals with those complexities, but I can't remember which paragraph. But if I would sum it up, this was a political project which was completing our struggle and the war. So we're ending a war. And there were conflicting interests at play of the old order and the new order. Within the old order, they differed amongst themselves as well, and within the new order. But in the new order, you had the old and the new in the same place. So there were even differences within the execution. You might all be NPA or the police, but the interests would be different. But I think what is more complex is that we set up the TRC not in the way the Act ultimately, did it. It's a compromise. The TRC Act, it's a compromise document. And we developed it to get the generals, the perpetrators, to come forward and say what they had done. But they had another interest, to say we want also the liberation movement. So it was complex. And then we were dealing with a fragile transition, and there were others who were saying let's not go back. Let me use an expression that was used during that time. It's don't let the past kill the future. I think it was like, don't stop the future by going back to the past. So there were people who felt like that. Remember, those generals were in place, all of them who commanded this place, this operation, were in the prosecution authority, in the police, in government for that matter. So I call it a political complexity, and people had different views, perspectives. I did indicate that I differed with my own comrades. Some of them were saying, no, but why do you pursue this case? And I said, no, you see, you were not a victim like I was. You were victims in other forms, but I want to know who did it. And now I know everything, the laboratory that was used, and just as a by the way, commissioners, the irony about this is that I became Director General, Secretary of Cabinet, and I had to deal with this vault of chemical weapons, create a policy for it, and how we manage the keys to control it. I mean, it's a real irony. That's the nature of our transition. And I had to talk to Stein and other people who managed that particular place. So the transition was complex. It wasn't just an easy one.
Yes, and Reverend, when council led you, you intersected the last part of paragraph 21, the last part of it, with paragraph 27. This is where, in these two paragraphs, you speak to the political complexities.
Yeah,
Yes.
yeah.
Yes, Ms. Nhloko.
Thank you, Commissioner Homo. We just needed the elaboration on that. And then, Reverend, to get back to that, because your statement, of course, is a statement, you then indicate, as you just did, are you able to give any further examples of how these complexities in actual fact played out in the government and in your matter in relation to the NPA?
Yeah, the problem with this case is that there were various sins at different places happening at the same time. And you know, if you watch a film, they show you that part as it happens, the other side. I didn't have the privilege of seeing all sides of the story. What I know, I can only talk about myself. What I know is that there were debates about how we should handle this matter. There were differences before the Truth Commission, differences after. And there were those, I remember in a meeting of DGs where there were others who were saying, whilst my case was running, you know, why should you pursue this matter? Because they're going to use it to charge the leadership of the ANC. So it's complex because you were, in a sense, there was too much uncertainty. People were still having plans to destabilize the new order. There were still plans to compromise those who are coming in. 2 years I arrived in government. About that time, I wrote a letter to President Mandela and copied to Deputy President Mbeki to say the old is corrupting the new. I observed it. And so as we're working together, if I was corrupt, I must corrupt the new so that they can't deal with me. You know, so that transition was complex.
Thank you, Reverend. Ms. Nkloko?
Thank you. Then speaking of that issue on destabilization, you deal with that primarily in paragraph 28 of your statement.
Paragraph
28
28, yeah.
of your statement. There you describe concerns that some individuals had about destabilization and the implications on prosecutions for the broader political transition. Can you assist the Commission by giving context? Because it's not as, it's there, but it's not fully articulated. In what context exactly did these arise? And where were these discussions happening? Because as I understand, you were not party to certain structures that we have dealt with in this commission. Were there other structures where these debates were taking place in the government? And do you remember who would have been part of those discussions?
No, I can't go into government and where those things were discussed formally. I mean, what I'm talking about is informal discussions. It would have been, for instance, I mean, there were debate about should we negotiate or not negotiate? Should we execute the war to the end? What will be the end look like? And it was a struggle to agree amongst ourselves that negotiation was the best route. But we still accuse today that that was not the best route. Some call it sellout. And so the debate is much more, what I'm talking about, it's a much more complex debate. Can we settle with them without taking them to prison? Because in a winner takes all, like World War II, you do Nuremberg trials, you charge all of them. But we couldn't do that. So that's what I'm talking about. The complexity is that it was not as easy as we have won the war, let's charge all of them. And so others would say, the negotiations have achieved what we wanted to achieve, so why do you want to continue fighting? My view was, victims are victims, and if a family member disappeared, they can't stop looking for the family member. And I also want to know how I was poisoned. So I had a different perspective. I wanted stability, yes. But you can't have stability at the cost of not knowing what happened. And knowing what happened was not just a personal issue. It's how you stop this happening in the future. It was more about future. How do we make sure this thing never happens again? You need to know to stop it. That was the objective. So it wasn't just for my personal interests, but to make sure nobody does the same in future.
Thank you, Reverend. Ms.
Thank you.
Nkloko?
And then just to clarify, these debates happened, one before the TRC, which is the transition period, but also post the TRC sittings.
Yes.
Okay. Then our last question. You indicated that at some point you felt like you were being used as a pawn to achieve, and you said their objectives. Just for the record, whose objectives and what were those objectives?
I knew then that the security network was not dismantled to deal with us. And their objectives was not, there were those who didn't want the settlement amongst the old order in any way. Some fought to the end. Bombs exploded a week before our election. So there were differences amongst themselves. There was a plan to destabilize us. And to a certain extent, some Some of those plans were achieved. That's why we are where we are today. So those plans were there, and we needed to overcome that without ignoring what happened in the past, but making sure that the future doesn't get arrested by the past. I think you could have decided we're going to fight to the end and destroy each other, and there were changes in the world as well, which forced us into that situation. That's the complexity for me. It's that it wasn't just a technical issue about charging people for the sake of charging them, but it was getting them to tell the truth. If they can't and we have sufficient evidence, charge them. But if you don't have sufficient, you may know that this person did this, but you don't have the evidence. Then you lose the case in court. And the court also, as I described it, it's not your court, you know. We're still working on transformation of the judicial system as well.
Thank you so much, Reverend. That will be all for our side.
Thank you, Ms. DeVos.
Chair, Commissioners, no questions from us.
Thank you, Ms. DeVos. Ms. Moroka.
Thank you, Chair, and good afternoon, Tate Moruti. Can I find out, we do know that on the 15th of April 2003, the President made a speech to Parliament, the unfinished business, a TRC unfinished business. You don't refer to it in your affidavit, am I correct?
I think I do refer to it, maybe not clearly. I say that the President addressed Parliament on the implementation of the outcomes of the Truth and Reconciliation Commission, and that's the speech which informed the debate about the guidelines and how you do it, because it's beyond the Truth and Reconciliation Commission.
And according to you, this was not a rerun of the TRC process,
No.
or the amnesty, a general amnesty for those who did not come forward. You did not understand that speech to mean that.
No, it wasn't providing for general amnesty. Otherwise, Flock and Van der Merwe would have got it. There was no general amnesty. You need to present the info and do plea bargaining. So it was going through a court process. It wasn't just you've got an amnesty, because there was no Truth Commission to do that.
And therefore, the speech could not have been understood to be interference in prosecution of TRC cases.
No, I didn't understand it that way. It's my understanding is, if you have evidence, you don't need to follow this process. Even the guidelines, charge them because you've got evidence. But if you don't, you want information, you go through the plea bargaining approach.
Can I move on to your relationship or your interaction with Advocate Ackerman?
Yeah.
If I may. In his evidence before this commission, the advocate had this to say: at it's day the 17th of, or the 26th of March, Chairperson, and at page 6 of his evidence.
What year is that?
No, I'm reading what he told this commission. I
Oh,
just want to
okay.
get your views on what he told the commission.
Okay.
He says, by all accounts, I accept that they have been successful to bring about the reconciliation. but the TRC Act has run its course and has been concluded and is now part of the history of South Africa. That's the first part of this paragraph. Would you agree with this statement? That the TRC has run its course and has been concluded and it's now part of the history of South Africa.
No, I wouldn't understand it in that way. There are bodies we're still looking for. We're still looking for people who disappeared. So in a sense, it can't come to an end. It's not the TRC per se, but the recommendations, people are still working on those. They have not finished, as far as I can remember. So it's history in terms of it happened at a particular time, but the consequences thereof are still with us.
He then goes on to say he believes in truth and justice and that there's a fundamental difference between reconciliation and justice. Do you think there's a difference between the two concepts?
I wouldn't contrast them in that way. Remember, we agreed on sacrificing, pursuing people who give us the information because we want the information. Without it, we can't do justice in any way. So there's a point at which the construct of the TRC allows for a person to tell you that I met at so-and-so, and you give them amnesty. If it was political, I think that's how I understood it. So contrasting reconciliation with justice, my understanding, that's why I'm saying we never achieved reconciliation. TRC did not achieve reconciliation. It achieved the object of getting people to come and say what happened to them and say what they did to others. We still are struggling with reconciliation up to now. I mean, that's why people still believe that you should forget about the past. Don't fix the economy. Don't do preferential, policies that help. Yeah. So you can't forget that. So in my view, reconciliation is completely different. I would say the distance we went with Flock would be said to be close to what reconciliation will be about, where he feels sorry about it, he asks for forgiveness, and even smuggled his skotlelki with a towel to come and wash my feet. That's beyond the TRC. So the fact that those police said, yes, we did this, doesn't mean there's reconciliation. So my definition of reconciliation is completely different.
Thank you, Fundis. And then you were asked a question by one of the legal representatives here present, whether Minister Mabandla ever responded to your letter. You do not know whether she referred the letter to the NPA or not, because we have evidence here that, in fact, she did refer that letter and asked for their response to the letter of complaint.
Yeah, I have no doubt. I expect a minister to do that. I mean, she couldn't answer all those questions.
Thank you.
In statecraft, she would have referred them letter in a normal situation to those people who need to respond, and her response would have been based on the information that comes from government. I don't know what happened, so I can't speak to it.
I was just informing you that for the record, she did send the letter to the NPA, and The NPA took your complaints seriously.
Yeah, no, thank you.
Thank you. Thank you, Chair.
Thank you, Ms. Moroka. Ms. Ranto?
Good afternoon and thank you, Commissioners. Good afternoon, Tatum Ruti.
Good afternoon.
Mine, I'll start by the meeting you held with Advocate Ackerman at your offices with Advocate Mhaga.
Yeah.
What did Advocate Ackerman say was the purpose of that meeting?
By the way, it's not the only meeting. We held a number of meetings with Ackerman. He came, I think, 3 times or so, and the last one was when we crossed paths together. In the past, it was, you know, talking about the prosecution, asking for information and what my views are. It's, I won't remember that detail. I remember the details of the last meeting because it was nasty. I couldn't have forgotten that. So he clearly, he had a different view about these things of guidelines and etc., that they don't meet the master in terms of the law. And I don't think he was interested in doing that. I think he just wanted to do a prosecution, and it's his job to prosecute. And I've said so that my worry was that I was suspicious that it's prosecution for the sake of prosecution, and they might go free because there may not be enough evidence to pin them down. I did say that I had more patience about get the maximum outcome on this matter because I had now sufficient information to press on it, and once they knew they would be charged, they would come out more clean. It was a game. It's a gamble. It's a game. And it wasn't a nice game, though.
And what, perhaps if I may just get clarity, the meeting that you're referring to as the last one is the one of January 2007.
Yeah.
Okay. And the reason why I was interested to understand as to the purpose of the meeting or how it was communicated to you is because evidence that's been led before the commission is that Advocate Ackerman was assigned to ascertain what your position was in relation to the prosecution of the matter. Hence, I wanted to understand as to what is it that he said was the purpose of that meeting.
If you go to the, I mean, when I read the letter to the minister, it reminds me that there was a document that was supposed to be signed or something like that. I had forgotten about it, but it's in the letter I refer to. And I think that document, I can't remember the contents thereof, but I couldn't agree to sign it. And that's when I think it turned around and became more hostile and declared me a hostile witness.
So the meeting was more about getting you to sign some sort of document?
Part of it, not the only thing,
Okay.
no.
All right. And then you also spoke of conflicting views within the government structures in relation to a case. Remember that, Madam Ruth?
Yeah.
What I want to just understand from you is that, well, having listened to your evidence, the view expressed during that period, I would say 2006, 2007, that about your reluctance to pursue the case was not incorrect in a way, isn't it?
What's the question?
The question is that view, because coupled with other issues that were raised, which situation led to an assignment given to Advocate Ackerman to go and consult with you, was to ascertain what your attitude was towards the prosecution in relation to your case. Now, my question is, having listened to your evidence, it would not be incorrect for those from government structures, it would not be incorrect to say that it was indeed your view that you didn't want to pursue the case, isn't it? Partly, maybe.
Yeah, no, I wouldn't put it in that way. I would say there were those who were concerned that the case was going to be used to destabilize the country. See, it's different from we won't pursue the case. It's a question of what are the implications of pursuing the way in which Ackerman wanted to pursue that case. Is he not intending to destabilize the country? Remember that the police also were not integrated fully. In fact, the liberation movement had no police to deploy. They had military people. So at the beginning, the police force, the prosecution authority was mainly old order. So there was uncertainty about what is he intending to do actually? What are the implications? And they had information about what Wagner, I don't pronounce that name properly. So I don't think there was a bad intention. There were different approaches. Okay. That's how I would put it. And even with me, that's why I don't want to specify a particular meeting, because a lot of the discussions could have happened in all sorts of informal situations. Even when we are at home and somebody visits you and you talk about this thing, there were views that were different. And there were differences amongst the liberation movement. If I say movements, then the differences even becomes wider. And there were differences within the government.
Okay. Yeah. And there was also evidence led that during one of the meetings of the interdepartmental task team, the resolution was taken that your position be ascertained. In other words, that there should be some engagement with you to ascertain what your position is in relation to your case. Now, I want to check with you as to whether, in your view, that resolution that was taken that your position be ascertained was not a reasonable request, isn't it? In other words, there was a need to ascertain.
Ms. Rand,
Thank you, Chair.
I think your question may not be a clarificatory question, stricto sensu, in fairness to the witness.
Okay. I withdraw. I do accept
Thank
that,
you.
Commissioners. Well, that will be all from our side.
Okay.
Thank you.
Mr. Vani?
Chair, from our side, some of our questions will traverse the bounds of clarification, so we will apply to cross-examine the Reverend.
Yes. Thank you.
We have no re-examination.
Thank you, Mr. Soni. Reverend Chikane, we recognize how difficult and traumatic it is to come before this commission to give evidence as you have given. And to that end, we wish to thank you profoundly for having come to give evidence under those difficult circumstances. For now, you are excused as a witness, but you may be recalled to be cross-examined. As you have heard, there is an intention to launch an application for your re-examination. We thank you, dear Reverend.
Thank you.
Mr. Semenya?
That would be the formal proceedings for the day, Chair.
Yes. These proceedings are adjourned until tomorrow at 10 o'clock.